Good morning. It is 10 a.m. on Wednesday, June 25th, and I am pleased to call to order this meeting of the Public Safety and Justice Committee. I will begin with a brief public service announcement, encouraging all of you to wear hats and sunscreens. This is what the alternative looks like if you need to have a basal cell carcinoma removed from your nose. Let's call the roll to establish the presence of a quorum.
Vice Chairperson Lee
Good morning, President.
and Chairperson Allenberg.
I'm here.
Great, thank you. We have a quorum.
Thank you very much. We'll move to public comment. This is the portion of the agenda set aside for members of the public wishing to address this committee on matters within our purview but not on the agenda today. We'll hear speakers first in chambers and then on Zoom. Who do we have, Nancy?
There are no requests to speak in chambers, and there are no requests on Zoom.
All right, then we'll move to approval of the consent calendar. Vice Chair Lee, I would like to add item 7 to the consent calendar. This is the annual report from the Office of the Sheriff relating to the use of naloxone in the Law Enforcement Services Bureau and Custody Bureau for the calendar year. I'll make just a brief comment if it's all right with you to keep it on consent, to move it to consent.
I do have a request to come back regarding.
And let's keep it on the regular agenda.
Okay, sorry.
All right, that's fine. Do you have any other items you'd
Nope,
like to
I don't,
place?
yeah.
All right, then I will move approval of the consent calendar as originally published.
A second.
All right, do we have public speakers on the consent calendar?
There are no requests to speak.
Okay. We're going to dive into our agenda. I'll note that item 8 today is a study session, so we're hoping to reserve a significant chunk of time for that piece, while of course giving appropriate and proper attention to all items that come before. Item 4 is to receive a report from the Probation Department relating to the 2024 Juvenile Justice Commission annual inspection of William F. James Ranch. And I believe we have Jill Ugalde making that presentation. Good morning, welcome.
Hi, good morning, supervisors. My name is Jill Ugalde, and I'm the Deputy Chief over the Institutional Services Division. With me today, we have our Research and Development team. We have Kim Lei and Li Wei. So today, we're here to present on behalf of the JJC's inspection report of the William F. James Ranch facility. Our commissioners were planning to be here this morning, but I don't see them in the audience. Oh. Perfect. They're in the back. So they are present here in chambers. In addition, we do not have a presentation for you all this morning, but we are happy to answer any questions that you may have.
All right, I will go first to comments from the public.
There are no requests to speak.
All right, then thank you. Thank you for the report and my appreciation to the Juvenile Justice Commission for your thorough and thoughtful review of the juvenile facilities. Probation's response noted that efforts are underway to reinstate furloughs and home visits. What is the anticipated timeline or progress toward resuming those programs?
So at this point, we don't have a timeline for the board. However, we are actively working on a process for OTs for our youth that are in the general program. We have been initiating conversations with the Youth Advisory Council in regards to parameters of what those OTs would look like and what would be most beneficial for that population. In the past, we've had to look at some challenges that we've had with OTs, specifically youth that potentially were in that contemplative stage that may not be wanting to come back to the ranch during that time, which resulted in ranch failures. So we're trying to set these youth up for success. Another challenge was when youth were coming back, bringing drugs into the facility. And as we know, fentanyl is rampant within our communities. So in order to keep folks safe, we have recently received delivery of the body scanners. So once we get our policies and all of those processes in place, we should have the capabilities to scan youth when they come back for those types of weapons, drugs, et cetera, that may be obtained while they're on these OTs. So as far as a timeline goes, we don't have a specific date, but we are working to get there.
I appreciate that. Thank you. And thank you for indicating that you are collaborating with the Youth Advisory Commission. Are there other system partners that you're collaborating with to facilitate the visits?
Yes, so in the past, we've also collaborated with behavioral health to ensure that the family unit is stable to receive the youth back for these home visits, as well as that the environment is safe. So we work with both of our staff as well as system partners to ensure that youth are stable. And if a crisis were to occur when they are home on OTs, what that intervention would look like.
Great. Thank you. Thank you for answering my questions, and thank you again to the Commission for your thoughtful work. It is so important that your eyes are literally on the ground in our facilities and making sure the board receives information we need to help direct policy improvements. Thank you. Supervisor Lee.
Yes, thank you so much. Yes, let me go ahead. First, I want to thank the commission and the staff for helping the board better understand what's actually happening at James Ranch, and it's certainly encouraging to hear that the programming is going strong with the collaborative efforts to support our youth. Also glad to hear that we're moving forward with tracking outcomes after the exit, and it's good to know that 76% of our kids feel good about their education, though certainly there's always room to grow. I would just like to ask to request some information to come back to us before the end of the calendar year, if this is possible. One is an off agenda on the status of last year's report recommendation. Another one is an update on the status of the responses probation provided in response to JJC's current recommendations. An update on the expanded data collection regarding the youth outcomes. And though not outlined in the report, I understand there may be some modification to the youth survey. So I would also like to request some updates on the progress of the survey modifications to come back to the JJC. Are these things that would be doable?
So just for clarification, Supervisor Lee, the survey that you're speaking of, is it the probation-generated survey or the JJC-generated survey that they facilitate during the inspection process?
I believe it's the, 1 second here. No, the JJC survey, the one that generated by JJC, yes, correct.
Wonderful, thank you.
Thank you. Yep, and that's all I have.
Yes.
Thank you.
Looking, I don't see any lights on from partners on the dais, so I will, Independent Defender Sylvia Perez-McDonald.
I really appreciated the report. It was really, really instructive and informative. I do want to sort of commend the probation department for one of the data pieces that we saw in the report was in the issue of disproportionate, in the disproportionality, and the fact that over the work done in the past, 15 years, there has been progress made in the disparity of youth that are in our system. We know that we can't control who comes to the front door, but once the youth come into our juvenile justice system, I think our probation department has done a really excellent job in ensuring that the disparity doesn't occur further down in the process. And I think that's a commendable effort that emulates and we should emulate in our adult system, because I think it's reflective of the institution's commitment to serving all youth and addressing also the unique needs of youth of color in our juvenile justice system.
Thank you for your comments. I think there's much we can emulate in the adult system from what we're learning in the juvenile. Thank you. Javier? Oh, Sorry, same light with Sylvia's light. All right, any additional comments, or would you like to make a motion to receive the report?
Yes, motion to move to receive report.
Second, let's vote.
Vice Chairperson Lee?
Aye.
And Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Thank you, and thank you to the presenters and a final time to the commission. Item 5 is to receive a report from the probation department, oh, you'll stay, relating to juvenile custodial grievances for the period of July 1, 2024 through December 31, 2024. Welcome again.
Hi, thank you. Again, my name is Jill Ugaldi, and I'm the Deputy Chief over Institutions for the Probation Department. With me today, I have Kim Lei and Lee Wei, and they are from our Research and Development Department, who will also be speaking on behalf of the grievances.
Perfect.
So today, we do not have a presentation, a formal presentation. However, we're happy to answer any questions that the board may have.
Thank you. Do we have public speakers?
There are no requests to speak.
All right, then again, thank you for this report as well. I want to focus for just a moment on the grievance resolutions. The report states that when asked whether youth agreed with proposed grievance resolutions, 70% at the hall agreed and 50% of the youth at James Ranch indicated agreement. Those are good numbers. Conversely, of course, 19% at the hall and 22% at the ranch didn't agree. So just focusing on that group, do you have data on which of those or what percentage of those youths initiated a formal appeal process and what percentage of appeals were either substantiated or overturned? Let's start with, is there an appeal process for juveniles?
There is an appeal process.
Okay.
So if a youth is not in agreement with the recommendation, an initial response will be submitted to that youth initially within 3 days. And then after that, if it's a health and safety grievance issue, it's addressed immediately. So those ones are addressed immediately. When it comes to final resolution, that's within 10 days. If a youth continues to disagree, they are eligible and/or we do a hearing with them where they're able to call witnesses. They're able to state whatever case they may have in front of a manager, and then a final decision is made.
Great. So what percentage of the dissatisfied youths filed grievances, filed appeals?
So there were no appeals.
So then the question, so no appeals could mean that they weren't happy with the resolution, but they're over it and moving on. It could mean that they don't feel comfortable initiating an appeal or are not aware of the appeal process. How do you inform youths who express displeasure that they have the right and opportunity to appeal? What kind of information do they get so they know how to move through that process?
They receive information in their the youth guidance book. So the process is outlined within that booklet that they get. Staff also converse with them in regards to what that process looks like and what their appeal rights are. As far as following up with those youth that were not in agreement with after the appeal process, we would have to get back to the board and or find another process internally to be able to follow back up with those youth after that process.
Thank you. I would like to see that iteration happen because you're making the effort to determine how many are satisfied and how many are not. So when you know specifically that youths are not satisfied, just ensuring that they have that awareness, I think, is an important next step.
So So I'd also like to introduce our probation division manager, Ms. Trina Gauthier. She works at the juvenile hall facility, but has vast experience at the James Ranch facility as well.
Perfect.
She's going to speak in regards to the actual process for the grievance and appeals.
Thank you. I understand the grievance piece, so I'm just looking to understand, to feel confident that the youth know that they do have a right to appeal and that it's not such a burdensome process that they're not interested in starting.
So when a youth is not satisfied with the discussion they had with the staff and then reviewed by a supervisor, and through that process, it does go down to management. We review everything, talk to who we need to talk to get more information, and then we do provide either if it's founded or unfounded. And I believe those notations, the RAD will confirm, the percentages are the managers if they agree or disagree with our final outcome.
Oh, that's what you're tracking here, the final outcome following
Yes,
appeals.
so after the whole process is complete, if they still may not agree, it didn't change anything, but we did go through the formal hearing process and with all the layers.
Okay, I think that's an important distinction in future reports to note who was satisfied initially, who was not satisfied initially, and who went through the appeal process. Does that work? Is that a piece that can be broken down?
It can.
Great, thank you so much. And on the good side, I know on the adult custody, I didn't mean it that way, it was inartful. On the adult custody side, I know we provide opportunities for individuals to share things that they think are working well, or offer kudos to staff, to surgeon officers. Is there any opportunity to share good news and positive information as part of the juvenile process?
There is. So we have
Okay.
several processes in place. The initial process is through our survey. We do a survey every 6 months with all of the youth in custody to find out what is going well and maybe where our challenges lie. In addition, we also have the Youth Advisory Council, that any peer that has any challenges or that may seek validation for any process that they may go through can go through the Youth Advisory Board, and they will then bring up any great things or any things that need changes to the proper individuals, which
Great.
would be management or supervisors.
Got it, lovely. Thank you for answering my questions. Not seeing light. Supervisor Lee?
Yeah, thank you so much for bringing the report to us, and look forward to see this report may evolve continuously to improve the experience of our youth moving forward on these type of grievance issues. So I would like to see, in terms of the future report, is maybe contain a little bit longer time period. I see you have a July to December on the numbers. On these charts, I think it's helpful to maybe even see a bit longer if these data are made available. If you could provide it to us in the future report, just keep the older record. Don't get rid of it. Just put it on the report so at least we could see how things have been evolving. I think that could be helpful. Are there any specific adoption of technology in terms of the use of grievances report in the future? I think that would be helpful to see as well, because I think there's so many things now, especially with AI and whatnot, right? I know all the information is confidential, but I think it could help process these information probably a lot quicker, and will resolve them a lot quicker as well. Yes, all makes sense?
Yes, thank you, Supervisor.
Okay, good. So among these grievances, what I thought was interesting on reading is that the majority of the grievances filed at James Ranch seems to be not sustained by quite a large margin, like it was 70-some%. So do you know why necessarily, why there are so many of those being sustained? Or is it just certain individuals who's filed multiple grievances that didn't seem to be real, or is it just that the conditions is actually not as bad as being complained about?
Supervisor Lee, I'm going to invite up our probation division manager
Okay,
from
thank
the
you.
James Ranch facility to speak operationally in
Sure.
regards to grievances.
Right.
This is probation division manager Frank Nessie.
Thank you. Ms. Nissy, yes. Oh, let's try the mic again. Yeah, the
No,
mic's
you
still
need
not
your
on.
microphone,
Yeah.
please.
Here we go.
We would most likely need to report back on that piece.
Sure.
I don't think we have that at this moment. I can tell you that a lot of the grievances, it's different than what you run into with a jail population. A lot of grievances have to do with either food, something that was off the menu, maybe a disagreement with.
I did those grievances for my daughters too, but that's different, yes.
So it is items that mean a lot to the kids at that time, but they're not reaching a high level as far as, you know, any Title 15 issues or that come across. But we could, right now, we don't have that information. We could
Okay,
report back.
yeah, that would be helpful. It just shows, it seems like it's like almost 3/4 of the grievance file has been unfounded, no change, which seems to be odd, especially compared to, say, the juvenile hall.
And we
yeah.
do run into situations where, you know, they do get points. There's a point process with their PBIS points as far as behavioral. If they misbehave, they can get those points deducted. So sometimes it has to do with just typical young juveniles having to learn to control behaviors.
Okay, yeah. So if you can get back to us on that, I certainly appreciate it.
Supervisor Lee, if I can just add to that as well. This is the first time that we're reporting out on grievances.
Right.
Some of our data does need to be cleaned up a little bit,
Okay.
and some of our collection methods needs to be refined. So we will definitely work on that at the
Great.
quarter moving forward, but that may be some of the reflection that you see in the percentages.
Oh, yeah. No, thank you for gathering these data, and this is certainly very helpful, but I would say let's keep it, and just in the future, we could continue seeing the trend. I think that could be very educational moving forward. Yeah, thank you very much. That's all I have.
Thank you. We do, I believe, have public speakers on this item.
We have one request to speak from Javier España.
Fantastic. Let's invite our speaker for 2 minutes. And just reconfirming, if anyone else is in the chambers desiring to speak on this item or in Zoom, now's the time to submit your card or raise your virtual hand. The queue will close when the first speaker begins speaking. Just want to make sure we don't have anyone else. No one on Zoom join? Go right ahead, please, sir.
Hi, so my name is Xavier Espana, and I was in custody in the juvenile hall, man, it was like 10, 15 years ago. But one of the first things I remember being told when I got in that facility was which COs or counselors are cool and which ones are not to be messed with. So I remember hearing that the grievances or the end results are low. And I think there might be two reasons for that. One might be for fear of retaliation. You know, because as soon as I got in there, I was told, like, hey, this CO, they'll take you to a blind spot, they'll give you a task, clean sweep in this area, which is a blind spot, and they'll use force, which might be, you know, I would be interested to see how many people or how many of these kids are filing grievances and then are in the item number 6 when they're victims of use of force. And then another reason why end results might be low as well, I've done grievances or appeal processes in CDCR where you almost have to be an attorney, right? You have to cite policy and codes and tie that and relate it to your grievance or your case. Asking a juvenile to do that might be very difficult for them to understand or put it in a way where an attorney, you know, does that on a daily basis. So I think that might be another reason. So I would be interested to see if it's a process that juveniles understand as well. And with that, thank you for your time.
Thank you. It looks like no additional comments. Is your light for a motion or
Yeah,
with more
we're
comment?
motion to receive the report.
Thank you. I'm happy to second that. Thank you.
Vice Chairperson Lee.
Aye.
And Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Thank you. The conversation does, in fact, continue with item 6, which is to receive a report from the Probation Department relating to the use of force incidents in the juvenile custodial settings for the period July 1, 2024 through December 31, 2024.
Thank you. Yes, that would be me again. So Jill Ugalde.
You're Jill, right?
Yes, Deputy Chief for Institutions. We also have our research and development team that remains seated up front to answer any questions as well.
Terrific. I will remember to begin this time with public commenters. Do we have any speakers?
We have 2 requests to speak in chambers, Alicia Chavez and Andrew Bigelow. If you could please approach the podium.
Thank you. Are there any speakers on Zoom?
There are no requests to speak on Zoom.
All right, confirming then that we'll close the queue with these 2 speakers.
Hi, everybody. My name is Andrew Bigelow. I'm an organizer with Silicon Valley Debug, and have been working with youth who've had cases within the county for years now, and related to use of force, but I think it's also relevant to items 4 and 5. Since the implementation of Secure Track, we've advocated for juvenile hall to be removed from that process entirely. It's a facility that is consistent with adult jails and adult prisons, and the experience of young people within that facility, I think, mirrors that. And and I know that, and from what I saw within the item number 6 in the report, that the number of use of force incidents within juvenile hall is almost double what it is at the James Ranch. And I think that just something to consider. I think there's maybe 2 factors to consider. That one is that facility was never intended to be a long-term housing facility, and young people already spending too much time pretrial in that facility. But then after pretrial, if they go into Secure Track, then they spend an even extended period of time within that facility, and that facility is damaging for mental health. Young people's spirits. It does not matter the aesthetic changes that happen within that building. It still is what it is. And then secondly, to pair with that too, is that the culture within that facility, because of the way it is, mirrors something of adult facilities. And the culture that COs and probation will interact with young people, even as you heard with Xavier before. That is something to be considered that may not show up. And so just want to encourage that to consider the removal of that facility. Thank you.
Thank you.
Hi, my name is Alicia. I am an organizer with Silicon Valley Debug. In regards to the grievances and use of force incidents, there will continue to be that as long as juvenile hall is being used to house youth, especially for long periods of time. And kind of echoing everything that Andrew has said, like each number in this report represents a young person experiencing a use of force in a system that should be focused on rehabilitation and trauma. We've heard too many stories of youth feeling unsafe, unsupported, and unheard through these facilities meant to guide their growth. These young people could be better served in community-based programs close to their families, schools, and support networks. As we continue to support young people going through the system, we continuously hear the issues within the juvenile hall, and especially things like this. I know that it's not during this period of time, but maybe a couple years ago, there's that counselor that was charged with assaulting a young person inside. And, these are one-off, people say these are one-off situations, but this is like a one-off situation that was caught. And I think more youth are experiencing, and like Xavier said about the grievances, not mentioning things like this for fear of retaliation, or like it's already a horrible time inside, and adding more hostility to the situation is gonna just make it worse. So You know, we've been calling to close juvenile hall and not use as a facility to hold youth for a long time. Thank you.
That concludes public comment.
Great, thank you to both of our speakers. Do you want to begin on this item, Supervisor Lee? Or-
Actually, yeah, sure. I just, well, I'm going to make a motion to receive the report first on this. So I just want to say thank you so much for the report. I certainly know that our staff has already reached out to get more details about the demographics for the future report coming back, and that you will be including that in there. So I just want to thank you for putting that in there. That's all I have for now.
Just one point of clarification on that. This report was delayed due, I think, to a change in agenda, and so the next report that comes will actually not have demographic data, but moving forward, all future reports will.
Understood. Thank you.
Great, thank you. I'm happy to second your motion. I'm going to add just a bit of direction, but first want to share, of course, appreciation for it. And while I was reading the report, I was reflecting on the adult custody system and kind of the various levels of internal and external oversight that monitor for excessive use of force or review critical incidents. And I realized that I don't have that same insight into or awareness even of the incident review process in juvenile custody. The report states that a referral to the Probation Internal Affairs Unit is made when warranted, and allegations of excessive use of force are reported to the Sheriff's Office for an independent review. Can you flesh that out a little bit more and say what language or guidance informs when a referral is warranted and whether there's a specific policy that would automatically trigger a review?
So referrals can come from anyone within the facility. Excuse me. It can come from our medical team that witness actual injuries and or bruising or anything that identifies that incident could be excessive force. It can be via the witnesses that actually witness the situation unfold before them. It can come from teachers, anybody that's within our institutions. Once a use of force referral is made or somebody alleges use of force, we then pull the actual tapes to review the incident and have that reviewed by both the Sheriff's Office as well as our Internal Affairs Unit. In addition, anybody can make a referral to the Internal Affairs Unit to include youth, parents, teachers, et cetera.
And then what is just take it a little bit further. So a use of force can be reported by a wide variety of initiators, for lack of a better word. There would then be security camera or body camera footage reviewed?
So we don't have body
you don't have
cameras, but
body
we
cameras.
do have video recorders that record corridors, units, anywhere within the facilities.
Okay, and then what is the reporting process to supervisors? Are there specific timelines for investigation, transparency around results and outcomes?
Investigations are immediate, so as soon as that's brought to our attention, we immediately go into our process of reviewing the tapes and calling those entities out to review the circumstance as it unfolds.
And then a report is made within a specified amount of time?
So
The findings are made?
Findings are made, and once those findings are made, it goes through the investigation process through the Internal Affairs Unit. Depending on what that looks like, it can be anywhere up to a year for actual findings to be made, but it's being investigated the entire time. And if criminal charges are necessary, the Sheriff's Office would then go through the District Attorney's Office and follow their protocols.
And is the year just in practice, how long it may take, or is there a statute or ordinance that requires it to be done within a year?
So I'm going to defer to our Chief Probation Officer, Mr. Nick Burchard.
Hello, Mr. Nick Burchard.
To answer your
Oh,
question.
wrong, the mic.
It's about now. It's on. Now it works.
Now it does.
To answer your question, yes. So through statute, we have up to a year, or depending or not if there are criminal charges filed, then It can go longer than that because the case, our internal process, administrative process is on hold until the criminal process resolves itself. Most of these cases that we're speaking of do not take a year.
Acting Public Defender Silver, did you want to add? I did not. You did not. We're just having lights on. Okay. Is there anything else, Nick? Or?
No, other than the process that currently exists, POBAR rights and Peace Officers Bill of Rights that staff have, the investigation starts, as Deputy Chief Ugalde mentioned, immediately. We call the sheriffs out immediately. There are a number of people, as you saw and mentioned, who have access to the youth. If the youth themselves feel that there was a use of force issue, that gets brought up, and we file that with our internal affairs as well and look into it. So it starts immediately from the first complaint, whether that's from a medical unit, which is an independent body itself, who will then file CPS referrals. So it goes through that whole process. And the youth doesn't even have to file the complaint themselves. It can be through medical, behavioral health. It could be their attorney. It could be another youth who maybe have witnessed something. It could be another staff, their probation officer, their parent, when they speak to their parent, which happens at times. So there's a myriad of ways that we'll look at those as possible excessive force.
And I was just going to add, Nick, that I think just to zoom out even a layer, I think and really kind of getting to the heart of your question, Supervisor Allenberg, there are, just by virtue of the fact that we have a very, relative to our adult custody population, tiny population of youth in custody at any given time, and lots of other kind of protective adults in the facility delivering services, just a lot more natural infrastructure in place and kind of eyes on than exist on the adult custody side, which is part of why you see us having needed to build an infrastructure on the adult custody side to offer some of those levels of review that are just naturally baked into the nature of the way our juvenile facilities operate by virtue of the relatively much smaller number of kids in custody and the expectations around service delivery to young people, the other folks they come into contact in the facility, the fact that we have this rich educational program, we have the whole custody health team, we have a very rich on-staff behavioral health team in the facilities, so that creates in and of itself kind of an additional layer of oversight and accountability that we unfortunately can't replicate on the adult side in the same way, given just the ratios of adults to young people in the facility.
Thank you. Sylvia?
So from a positive perspective, the survey showed that most of our kids in there feel safe, right? So that's good. However, I think one of the speakers made a really good point about our ability as a system to address the concerns of our youth really rests on whether we have a healthy institutional culture that accepts the feedback from the youth and that the youth feel safe to deliver that feedback. One important thing to take away from today's conversation is the reference about retaliation. If indeed one or two youth feel that they are not safe enough to speak out because one of our staff in the facility could potentially retaliate, however that is defined, we need to really look at that, because we want to be able to have them report incidents, have us address the incidents, and regardless of whether the statute allows for a length of time to address it from a legal statutory perspective, liability perspective, the focus, though, it should be on how the youth is being treated and how the youth is responding, how the youth is feeling. Why? Because as an institution, we fail if that youth is so worried that they cannot thrive, they cannot be educated, and they do not succeed. So I think that from all of this is what we should take away from, and we should figure out a way of incorporating it either in the grievance process or in the training of our staff or in any other way. So it could be in the survey, for example, and being addressed sort of openly.
Thank you. That's really insightful.
I might
Damon, go ahead.
Yeah, I might briefly add, and Nick, you may be able to flesh this out, but we were fortunate to be hosted for a recent tour of the juvenile hall. And an area of the hall that I wasn't actually familiar with in their medical location was an actual room where you could request, I think, access. Does this sound correct, Nick? Where you can request access to a phone to make, in essence, any version or anonymous disclosures about concerns, which I thought was rather creative and unique part of the structure at the hall that I wasn't aware of, and I thought at least was encouraging in terms of the ability to get access to make disclosures and concerns known. I realize it doesn't address all the concerns about retaliation, but it seemed to be a unique and novel way of at least allowing another avenue for our youth in custody to report concerns that they're experiencing.
He's correct. I have nothing to add to that other than, yes, there's many different avenues for a youth who feels unsafe to reach out, and even if it's to their parent or caregiver. And then we would open up an investigation based on that as well. So, I mean, there are many, many different avenues, and I mentioned whether it's with their attorneys, we offer any avenue that the youth feel that they need so that we can obviously protect them and protect other youth in the event that there is something going on that we need to explore.
Thank you very much. I'd like to add two requests to the motion that Supervisor Lee made. One is when you next report to this body. First, we've talked a lot about the process, but I would like to see just a documented description of what the process looks like once a complaint of excessive use of force has been initiated. It sounds like a lot of this is informal and it's maybe entirely sufficient, but I'd like to see the formal structure as well. And with regard to the earlier item, I didn't ask for this on item 5, but I will put it in here, and I heard the speaker on that item note the potential complexity of the appeal process for a youth. I would like to have you include in the ledge file a copy of what the youths receive in order for them to initiate an appeal to an outcome that they are displeased with. What are the steps that they have to follow? Just so that we can all have eyes on the language that's used. Is it age appropriate, developmentally appropriate? Are these reasonable expectations for a youth to be able to follow? And if there's discussion around ways to improve that, I hope that you'll be open to that. It may be perfect as it is, I don't know, but I would love to have that discussion. Are both of those additions all right with you?
Yes.
Okay, great. Thank you very much. Let's vote on this item, please.
Vice Chairperson Lee?
Aye.
Chairperson Ellenberg?
Yes.
Thank you. Motion carries.
Thank you very much. Item 7 is to, and thank you all very much from the Probation Department. Item 7 is to receive an annual report from the Office of the Sheriff relating to the use of naloxone, which is Narcan, in the Law Enforcement Services Bureau and Custody Bureau for calendar year 2024.
Chair, I know you were planning to move this one to consent, and I don't need to see the presentation. I actually do have some questions. I'll
Do you
follow
want
up.
to ask your
And to-
questions first or have public comment
Yeah, let's do
first?
public comments first, but I just
Okay.
want to say.
Is
we
there
need to
public
report.
comment on item 7?
There are no requests to speak.
Okay, go right ahead, please.
Okay, good, sure. So first of all, thank you very much for the report. Having drugs in custody, custodial facilities in jail, continue to be a very serious issue because it puts the safety of our deputies and those incarcerated all at risk. So what I would like to ask is a report coming back to the Public Safety and Justice Committee with some elaborate, some details on how the drugs are really entering into our jails that we suspect, and what type of current measure or potentially suggest additional measures that needs to be put in place to prevent this, and any other additional steps that you could recommend. I would like to see the available data on the drug-related incidents that happened inside the jail, the type of screening and monitoring protocols, staff training practices, and the challenges and the gaps in these type of enforcement. Basically, what I'm looking for is trying to find ways to do a better job to prevent these drugs getting into our custodial facilities. That's the bottom line.
Do you want
Yes,
to
Captain.
make that a motion for a
Yeah,
a
may I make that a
report?
motion to receive report and include those items in there, please?
Good morning, Supervisor.
Good
Yes,
morning.
we'd be happy to bring a report back.
Okay, good, good. I mean, I'm having seen the, yeah, so I have a motion, would you
Okay.
second that? Yeah,
Second.
so my just question really is, the technology being used to get get the stuff into jail is certainly matching the technological advances we see. Having drones, I mean, we know drones being used in wars and whatnot, but being used to deliver packages in this case, and potentially our waste that gets in our jail, something that was very disconcerting. Not that we need to build an iron dome on top of our jail, that's not what we're doing, obviously, but I do think there are ways that we could do a better job of trying to track these things if possible. And, I see the lights on the council here. Sorry. Go ahead.
Just a very
Go
quick,
ahead, Kavita.
thank you. Very quick comment on the drone point. The board passed an ordinance a couple of years ago to prohibit exactly
Yep.
that.
Thank you.
Okay.
Do you have anything else?
No, so I just want to know what type of measures been taking place. Now, if some of these measures that you adopt, you believe should not be public because of the fact that this is, you don't want to let the guys know how we are going after and catching them. If you can make it a confidential report to the board or this committee, I would really appreciate it.
We do that.
Thank
And
you
just-
very much.
Just to touch on a couple of those
Sure.
things, I know we're really short on time, but we are expanding our canine drug detection
Yes.
program. We do have the body scanners that we utilize, and we are also looking to expand, like you mentioned, our drone program.
Exactly, good. Thank you very much, that's all I have.
Thank you as well. I imagine that we are seeing a higher number of drugs being intercepted in custody, in part, I think, because of your increased efforts to locate them and to protect the safety of individuals in our facilities. So while it's troubling to hear the higher number, it's also reassuring that you are finding more and ideally keeping folks inside a little bit safer. I understand that Custody Health and the Sheriff's Office are working closely to establish monitoring protocols as well for individuals experiencing withdrawal, certainly trying to tamp down the need or desire for drugs in custody may help these efforts as well. So I would like to add to your motion, Supervisor Lee, a request for Custody Health. I know they don't report to this committee anymore, they report to HHC. So the report could come to HHC and then I can read it from there if that's all right.
Sure.
A report from Custody Health on withdrawal care, including the use of medication-assisted treatment and any related policies for special supervision to come back to an HHC meeting.
Yes, absolutely.
Terrific. Thank you very much. I don't have anything else. I don't see any lights. Thank you for the report. We have a motion by Lee, a second by Ellenberg.
Vice Chairperson Lee?
Aye.
And Chairperson Ellenberg?
Yes.
Thank you, motion carries.
Thank you very
Thank
much.
you.
All right, this brings us to our study session, and I will introduce the topic by noting that while I understand certainly that the Board of Supervisors is not the decision maker regarding bail, we are certainly heavily invested in this issue because of the ancillary impact and often direct impact to many of our systems, programs, services, and certainly budget. These study sessions provide a critical and unique opportunity, I think perhaps one of the only forums where decision makers, community members, and key stakeholders can come together for open and constructive dialogue about the significant issues that impact our system. In my opinion, the discussion on $0 bail really exemplifies the highest and best use of committee work. We are fostering informed, inclusive discussions on complex policy matters that impact our residents. I want to emphasize for members of the public in particular tuning in that this is just one in a series of ongoing conversations focused on identifying effective strategies to safely reduce our jail population. The concept of $0 bail was initially proposed during the Alternatives to Incarceration work group and was later reaffirmed by Dr. Austin in the jail population assessment as a recommended approach to help achieve that goal. So the structure for today is that we will begin with a presentation by the district attorney and administration. Then we're going to hear from DBUG, and I'll invite Raj Jajayev, if Raj is the presenter, to join us at the front table. And we have an individual from the Civil Rights Corps who will be joining us on Zoom, so we can promote them at this time. And then we'll hear from, after them, we will hear from Judge Gaffon before taking public comment. Then we will open the forum for questions and discussion. I'll also note that we've received a report, a letter and supporting documents from the Public Defender's Office, and I will certainly look to Acting Public Defender Silver for participation in this conversation as well. So, DA Rosen.
David Angel from the DA's office will give our presentation.
Perfect. Welcome, David.
Supervisor Casey Halkin, Deputy County Executive, if it might be helpful if we begin first with administration's presentation about the jail population data, if that's okay.
Absolutely
to set the stage
fine.
a bit?
Sure.
Is that all right with you,
all right
David?
with you, David?
Okay.
Okay.
Thank you.
Thanks, Casey.
Thank you, Supervisor, for that introduction. Casey Halkin, Deputy County Executive. As you mentioned, this will be a collaborative and multidisciplinary presentation. We will also be joined likely after the District Attorney's Office by County Counsel, who will be talking a little bit about the county's role in implementation. So thank you for setting the stage. As the supervisor mentioned, and this is for members of the public, $0 bail has been recommended as an ongoing strategy, but it really was implemented initially as a part of our response to the COVID pandemic. So the unique circumstances created a situation where we had concerns about epidemic within our jail system. So the Judicial Council of California issued a statewide emergency order in April 2020, which set the statewide schedule of $0 bail for most misdemeanors and certain felonies. So what this meant practically is that individuals charged with these offenses would have their bail set at $0, and after undergoing booking procedures, they would be released without any monetary payment. So the Judicial Council actually let this expire in June of 2020, but our local Superior Court took the action of extending $0 bail through July of 2022 when it expired here locally. Since that time, our Superior Court has moved forward with a more traditional schedule, but I do want to highlight a couple practices in Santa Clara that I think are anything but usual, which have really led to us being able to, I think, keep the jail population not as low as we would like, but lower than many other jurisdictions with similar population. Next slide. So I'd like to draw your attention to the jail population slide here. So we have noted, you can see between those orange lines there, the period of time that $0 bail was in place in Santa Clara County. And what you will note is that prior to the pandemic, we had a jail population that exceeded 3,000. And there was a precipitous plummet down by about 1,000 when $0 bail was implemented, and then even further down in the height of the pandemic in July and October of 2020. We had $0 bail for longer than some jurisdictions, and you will note that we did see a steady increase in the jail population, even in the midst of $0 bail, but thankfully, we have not seen a jail population approach what we had prior to the pandemic. And I really want to take the opportunity to highlight that because I think that is a unique circumstance we have here based on the collaboration efforts of many people at this table. So we certainly have a district attorney who's led through his Bend the Arc initiatives and his policies around bail. We also have a public defender and a DA's office who've worked very collaboratively around PAR and mental health arraignment. We've, of course, had the leadership of the Board of Supervisors, you in particular, Supervisor Ellenberg, around alternatives to incarceration and diversion. And the reason why I think that's important is the last day of $0 bail in our county, we had a jail population, which was July 30th of 2022. We had a jail population of 2,752. And on the day that I submitted my slides and did the data collection on that day, which was last week, we had a jail population of 2,792. So we had a difference of 40 individuals. And certainly we would like that number to be lower. There's certainly more effort that we could do, but keeping that population within 40 from the last day of $0 bail to today is really because of some of the unique strides we've taken to increase pretrial services, collaboration, diversion, and alternatives to incarceration. Next slide. So you will note that some trends, which we've highlighted in our quarterly reports as well, continue to be in effect throughout this time, which is to say that most of our jail population continues to be our felony unsentenced individuals. I would also like to note, again, the collaboration between the public defender, the district attorney's office, and the court to really move through the criminal backlog that impacted most superior courts throughout the state resulting from COVID. We've made a lot of progress on that in cooperation. And we've been able to see particularly our sexual assault cases moving through at a more rapid pace, which is meaning that our jail population has decreased some. And because of our alternatives to incarceration policies, because of our diversion and pretrial, we continue to have a jail population that is largely those who've been accused of committing felonies. Next slide. So this is a jail population snapshot, and you'll note that we have the date of June 17th. The jail population, it's important to note, particularly for members of the public, ebbs and flows on an almost hourly basis. So you could take a jail snapshot on a Tuesday, and it would look very different on a Thursday when people who were booked on the weekend are released on a Wednesday. So the date and time that you take that snapshot is really important to make sure we're noting that, just because, again, there is a pretty significant fluctuation from day to day because of booking. But again, what this reflects is you'll note that most of the jail population, approximately 85%, is made up of people accused of committing felonies, and the misdemeanor charges are around 15%. And that's where we could make some significant improvements, because people who are in custody for misdemeanors tend to fall into two categories. One, which is what we consider our more serious misdemeanors, which are domestic violence and often DUI or driving under the influence. But there's some what we call misdemeanor churn of people who are booked in, staying a few days, and then leaving, and that tends to be that 15% margin. I believe that is the last slide that I have to share for our administration perspective, and certainly we will be available to answer any questions, but we just really wanted to set the stage with the jail population. Next, I'm going to be turning this over to Assistant District Attorney David Angel, and then after I believe we will be joined.
I think we have, Kavita is going to present as part of the
my
administration.
apologies.
Thank you. We have many participants who are very interested in speaking on the topic, as you can see. The reason that it seems helpful for me to go next is before we have the system partners speaking in detail about what they're observing as direct participants, I can offer a few more table setting comments about the system at a high level and the county's role in particular. So I thought I could rewind and just first say a couple sentences about how bail is normally set in a non-pandemic, non-$0 bail world. Casey described the circumstances under which the Judicial Council set at a statewide level the $0 bail schedule. Under normal times, the law prescribes a process in our state where the judges of each superior court for each county vote on a bail schedule that assigns a dollar amount to each offense, categorized statute by statute. In the county's piece of the system, under the penal code, as you pointed out, Supervisor Ellenberg, the county has no role in bail setting under law, cannot have a role in that. And On the implementation side, when people are booked into jail, the sheriff is the official who accepts bail at the time of booking, but has no discretion to depart upward or downward from the amount set in the bail schedule. They must accept the dollar amount set by the court. Only a judge can change that amount. Now, the process in our county, due to collaborative efforts by the law enforcement agencies and all of the other system partners, is such that arrest often leads to cite and release and not booking into the jail. Even where someone is brought to jail, transported into the jail, they don't always have monetary bail set because we have such a robust pretrial services program that offers non-monetary release options. And we've done a lot of work as a system to offer a very robust set of options in that regard. If a person is going to be paying bail, as I noted, the county must accept it only at the scheduled amount, and then at the first appearance, the court would have the opportunity to alter that bail amount. And this, makes our system here in our county quite different from what we see in some other counties around the state. So I'll just offer that by way of foundation, and then I can respond certainly to any other legal issues that come up.
Thank you very much. David Angel from the District Attorney's Office.
All right, I think I've gotten the mic to work. Okay, great, thank you. Oh, wonderful, you've already done it. All right, as you may know, I'm pinch hitting for my colleague, James, today, but we've worked on a lot of this together, so I hope I'll be able to answer your questions. Why don't we move to the next slide? I'll move through the first few slides relatively quickly because I think my colleagues have already presented on this. But just I'm not entirely sure what will be helpful, so I thought giving some context that lays the groundwork for some of our way of perceiving it would be helpful. So just a reminder of where we are today. So most people pending, even though most people in our jail are pending trial, most people who are pending trial are not in jail. The vast majority of them are out of custody. Most of the people who are out of custody are not paying any sort of bail, and they either have no conditions aside from to appear in court, meaning an OR release, or they have some other conditions that are usually monitored by Mr. Fisk's organization and set by the court. It's important to remember the jail population is steadily, well, I won't say steadily, but systemically gone down. Certainly, if I look when DA Rosen began, we've had, I think it's about a 2/3 drop in the jail population. Then right when COVID hit, we arranged with a collaborative efforts. I know I see Damon and Charlie here. We both worked on this a lot, as well as I believe Judge Gaffon, you are actually our judge, and we reduced the jail population by 1/3 again. That was before the $0 bail schedule actually took effect, and that's in large part because this county, and I remember a hearing at this with the board right at the beginning of COVID when the various actors around this table got together and said, look, we have to do something about COVID and about the danger of an outbreak in the jail. And so that led to about another 1/3 in the drop of the population. Then $0 bail was initiated, and as you saw from the chart, it didn't really, I don't know if the numbers ever got much lower than what we had gotten it to during those efforts, but over time they began to go up. And the other thing then I think that's important to remember is that over time we've really shifted the population who is in the jail. When I began as a prosecutor way back in 1995, the vast majority of people in jail were there for relatively minor charges, drunk in public, DUIs, drug offenses, and so on. Through a variety of efforts of both us and also law enforcement, now the majority of people in our jail are in for very serious crimes that they've either they've been charged with or convicted of. Next slide, please. This is really just emphasizing the same thing, but pointing out that we have a lot of off-ramps before someone ends up in our jail. I mean, because if you don't have those off-ramps, you end up with more of a traditional balance, which is far more nonviolent crimes or minor crimes. As we know, our police are actually quite selective on who they cite and release and who they book. We know that our jail is quite selective of who they will accept and who they release. And then when people are released, it's usually with some sort of condition, with only the very smallest portion are being held without bail or with a bail beyond what they can afford. Next slide, please. All right, so this is the number, and I've actually exchanged emails just this morning with a number of people asking how we derive this. But our calculation is that roughly 84% of the people in our jail are in for serious or violent felonies. Because there have been some questions, let me elaborate on that a little bit here. As is always the case with data, it's sometimes a little confusing to know if you're all looking at the exact same thing or calculating it the same way. But essentially, if you recall back to the slide that Casey presented of the breakdown in the jail, it showed that roughly 60% of inmates were in for violent felonies or homicides. So some might say, well, why shouldn't that just be 60% then? Where do you get this larger number? Well, you might recall that the next larger group was other felonies. And then there was another category, which was property crimes, and another that was drug crimes. In the past, and for this presentation, when we look at what other felonies are, those are mainly felony domestic violence cases and other cases like that. In other words, the term serious or violent felony is actually a term of art that's used in very specific legal ways, but are not really what most people, they're far under inclusive. So for example, if somebody were, I don't know, to take a crowbar and threaten to beat up his girlfriend or wife, that may or may not be a serious or violent felony under the legal enhancement, but I think we would all recognize, okay, that is in fact what we would all consider a violent crime. I certainly would. So that's where we get it. If you add those two numbers together, you get to roughly 84%. The remainder are for property and drug crimes. And then, of course, there are misdemeanor crimes. That's actually a tricky, I know Casey had said that's an area we might, and I certainly hope we'll have some progress on. But in my experience, that's actually a trickier group to deal with because they're either quite serious ones, even though they're misdemeanors, let's say domestic violence or DUIs, or they're people who have previously been released from custody, either pursuant to diversion or pretrial release, but have failed to appear in court or failed to participate. So it becomes very challenging to divert people or to bring them any sort of rehabilitation when they don't show up. And so that's often that number of people. And while it's a churn, it's not a churn so much because they're getting a really low sentence and they're done. It's a churn because it takes a day or two to kind of get them back into whatever program that they had left. Now, naturally, that's a complicated issue, which is why we have now, and I know it was, I think, my colleague Charlie's initiative, which my colleague from my office, Brandon Cabrera, worked on a lot. We have the pre-arraignment calendar now, and we also have the pop-up courts, which are brought to the community to try to address it. All right, next slide, please. And this is, of course, what I just talked about, the relatively small number of people who are in for the reasons I just said, who are not in for a serious or violent felony. Next slide. All right, so in a way, one thing I really want to emphasize is that questions about the question of should or should we not have $0 bail, I think in some ways I would suggest it's maybe not the right question. It's important to remember, I mean, I know that sounds a little arrogant, but what I mean by that is it's important to remember that the DA's office, DA Rosen, we were one of the first in the country to stop seeking cash bail as a condition of release. At that time, I think DA Krasner from Philadelphia, who many of you have heard of, he had done that prior to us. But our policy, when I studied it, is actually more expansive than what they had, and when we would not seek bail. Essentially, our position has always been, or has been since the DA, and continues to be, in general, people should not be held pre-trial in jail. And if there are conditions that allow for their safe release, they should be released. Cash should not be one of those conditions. On the other hand, people should not be released for no other reason than they can pay for it if it presents a danger to the public. So our core mission in some ways is that when somebody is brought into the jail, that there's an evaluation as to whether or not they can be safe released. If they can be, they should be. And if they can't be, they should not be, which is why our deputies either ask for people to be detained for public safety reasons, or they ask for them to be released with conditions, usually supervised by Mr. Fisk's organization. Next slide, please. And that, sorry, I anticipated my slide again. That's really our two goals, is even if we say there's $0 bail, remember, $0 bail, it just is a guideline. A court has the independence to decide what are the appropriate conditions, And that is, in fact, kind of the rub, and why I suggested maybe it's not the right question. If whether we set the schedule at 0 or not, a court is still going to review the case and make decisions as appropriate. Since we are not asking for bail, whether it's 0 or something else, that's the starting point, is not really of much significance to us. And I put down mental health intervention. In part, that's because that's my team's and something I have great concern about. But of course, we know there's a lot of people in our jail who are struggling with mental illness, and if we could address that mental illness factor, we can get them out of the jail quicker. And that's, of course, a lot of that 15%. And so the last slide is really just a reiteration of what Casey just showed you. The numbers are a little different, but this one is, you'll see the last day of $0 bail. You'll notice that the total population is about identical to what it is now, almost depending on what day or what hour you get the data, which is why I suggested, since this is the last day of $0 bail, and now we're today when we don't have $0 bail, and we can see it has not seemed to impact the jail population in any really measurable way. I think the reason is because the DAs are not asking for cash bail, and the courts are imposing other conditions or no conditions at all except a promise to appear when appropriate. So that's why I'm not sure the $0 bail schedule will really make a huge difference, but these are the backgrounds of where at least I came to that conclusion. Thank you.
Thank you very much. I'm going to switch the order a little bit. Damon, did you want to comment in here?
I can briefly comment here, or I can defer, whatever.
Your preference?
Let me, I'll
You can do
just,
both.
I'll make a couple brief comments and primarily defer. I know that we have our partners from Silicon Valley Debug and of course
and
the
the judge.
court and Civil Rights Corps, who I think are incredibly informed on this. For the sake of efficiency, I did provide a letter to be submitted that I think summarizes much of our position and view. I would uplift or just flag one area that I'm particularly curious in is the county's role and independent authority in the context of misdemeanors and the potential setting or release in the context of misdemeanors, as well as the policies that currently exist. As I understand, there's an agreed upon amount that allows the sheriff's office to, in essence, cite and release people as they're being booked if the bail setting is, I believe, $15,000. I can't recall if that had been increased to $15,000. So it does feel like there may be some additional levers that I would be curious that are independent of the court and the court's position. I think the last thing I would simply highlight is a request or interest in terms of data, because I think we commonly will speak to the point of, for instance, maybe $0 bail doesn't necessarily impact the population because the population at this point is very similar to the population number the population number at the last day of $0 bail. First, I would suggest ideally we would continue to, if we can do it safely, continue to reduce the jail population for all the reasons I stated in my letter. But I'm curious about the individuals. Can we dig into the data to determine which individuals are eligible or would technically be eligible for $0 bail, but as has been suggested or reported, maybe are not being released for other reasons? I'd like to understand what those reasons are. And in terms of this context about data, the second area is what I call override rates, and we saw this in the juvenile context, for instance, many years ago, which is how do override rates, how do we set a good policy, but somehow override rates or decisions to override that policy actually impact outcomes? And we fixed one of those issues in the context of detentions of our African-American youth in violations because we had identified that there was an override problem. Right now, or recently, there was an institution of a new worksheet that can be provided by law enforcement that in essence asks for an upward deviation. I mean, in theory, it says mitigation and aggravation. I'd be curious if that worksheet has ever been used by a law enforcement agent to argue for lower bail. But even if it hasn't, how often has it been used and how has it potentially led to increased a deviation upward. And similarly to David's point, I applaud DA Rosen for his advancing of a policy not to request actually cash bail. But I think there is an exception to that general rule, which is if an argument has been made for detention and the court has said we are not going to detain, I think the deputy district attorney has the right, in essence, to then override and request a high bail, not for bail setting purposes or really for the outcome of a de facto detention. And my question always is how often is that happening? You know, and watching those override rates that can impact good and well-intended policies and our ultimate jail population. That's what I wanted to just say at this time.
Thank you very much. I know I've shifted our order a little bit. I'm going to go to the court with the actual authority on this issue.
Supervisor, if you will allow me, I just wanted to add one more comment as we kind of wrap up the county presenters and transition to the court, which is maybe just a reminder for the community more than anything else of why we also agendized this discussion of $0 bail and why we keep talking about the jail population. But I would just say a few things. One, as the board is well aware and everyone on this part of this discussion is well aware, the reason that we are talking about our jail population is that we have decrepit jail facilities and not the appropriate capacity institutionally to deliver the care we need to deliver to folks in our custody in order to keep them safe, healthy, and well when the court remands them to our care. So we're trying to work collectively across systems to reduce the jail population in order to give us the number of people in custody, only those in custody who need to be in custody, not including in custody those folks who, as Mr. Angel, I think, articulated the county's philosophy as well, which is we shouldn't be using people's ability to pay as a reason that they end up in our custody. It should be a pure assessment of whether they can safely remain out of custody, and that's what we hope and know is a shared philosophy, at least across all of the county departments involved in this process. But I did want to just express for the public's understanding that a key opportunity for us to really meet expectations in delivering appropriate, safe environments in the jail is really making sure that population is a size that's manageable in the facilities we have with the staff that we have. And so that's really the impetus for this conversation. And I would just say making sure that we're leveraging the bail policy that allows us to advance that is something that the organization wants to work on in partnership with the court. So that's kind of how we come to this conversation, at least as county administration, and also did want to note that this is one part of a real broader strategy. And so one thing that I would just emphasize from, I think Damon's comment summed it up well, that we have implemented in partnership with the county departments involved in this, a number of strategies that would have reduced the jail population further, at least in the view of administration, below what it is today if $0 bail were still implemented, because those other strategies are, in our view, what has kept the jail population at the level it is today, akin to what it was when $0 bail went away. And so I think one of the things that is challenging as we look at each individual piece is keeping in mind the fact that we are collectively implementing many different interventions, including incredible amounts of additional work by the district attorney's office, public defender's office, our independent defense counsel office to really tackle, in partnership with the court, lots of steps by the court as well, to tackle what has also been a really significant backlog of cases actually getting ready to move towards trial status and either get resolved or go to trial. That was also ballooning our jail population. And so I want to note the existence of those efforts, maybe as we transition to the court, which I think have allowed us to keep the jail population where it is. And without those non-bail related efforts, we'd have a much higher jail population today than we do otherwise.
Thank you always, Greta, for keeping us aware of the framework and the context in which we are working and having conversations. Judge Gaffon.
All right, thank you very much for having us here, and I really do enjoy the collaborative nature of this conversation, and I hate to start my portion of it by talking about what I can't do, but I do think it's important that, as most of you know, but I want to make sure the public is aware that judicial ethics rules prevent a judge from commenting publicly or non-publicly about cases, controversies, or issues that are likely to come before the court. So what I cannot do today is give you an opinion or talk on behalf of the court about our position on bail policy or the jail population. Is it too high? Is it too low? Those are things I simply can't get into. But what I can do, and what I hope to do today, is share some factual background and some of my observations that I think are relevant to this discussion. I think what Greta just said is, I think, really important. The jail population question, I think, is a very complex one. Bail policy is a portion of that, but it's definitely not the only contributor to what is the jail population entirely. The Penal Code requires the court to adopt a bail schedule every year. The court has discussions about that in a robust way every year, I can assure you. We are not able to do that publicly for the same reason I just mentioned. Because we can't talk about these issues and express opinions publicly, we can't have a meeting publicly about it, because that's a meeting where we're all expressing our opinions and discussing different policy issues. So I can assure you that it occurs each and every year, but it is done just among the judges so that we can do it consistent with our ethical obligations. What I can tell you now is today, the current bail schedule, and this started in 2024, although we don't have any $0 bail offenses in our current bail schedule, there is a presumption for misdemeanor offenses that a person arrested will be released on their own recognizance. There are some exceptions to that. People who were already out on a release at the time of their of the time of their arrest, if they were already on a release. But there is a presumption in our bail schedule now that someone arrested for a misdemeanor offense, with certain exceptions, will be released on their own recognizance. Those OR presumption offenses very much mirror what would have been and what was at the time of the zero bail schedule, the zero bail offenses. So although it's not called zero bail, I do think it has a roughly similar effect currently. It's also important to, I think, recognize that the bail schedule, while a very important document, is more limited in its effect than it used to be. The Humphreys case that most of you are aware of changed the way custody decisions are made by judges in court. The bail schedule is no longer a part of that discussion. Judges are making independent decisions about non-monetary means that can protect the public and can ensure a defendant's appearance in court, and we do that without reference to a bail schedule. We also have, thanks to the collaboration with Mr. Fisk and his organization, and the county, of course, as well, we have a very robust pretrial services office in this case, in this county, and the court has a judge, at least one, on duty 24/7 to review arrests. And so what happens is, when someone is arrested, they do have the right under the law to post their scheduled bail, and they can do that immediately, even before anyone reviews their case. But if they don't post their bail, within about 6 hours or so of their booking, there is going to be a judge who is going to review that case. There's going to be a report from pretrial services that's going to tell the judge whether the person is eligible for a release. Some people under the Penal Code are not eligible to be released on their own recognizance or supervised own recognizance. That's Penal Code Section 1270.1, that says mainly for serious and violent felonies, as well as most domestic violence offenses, a bail cannot be set that is higher or lower than the schedule until a hearing occurs in court. But when we review these cases as they come in individually within about 6 hours of the arrest, there's a report from pretrial services. If a person is arrested on a low-level felony offense or any felony offense where they are legally eligible to be released, that is flagged for us, and the judge doing that review will look at the report, will look at the defendant's background, and determine whether or not they can be released or should be released on their own recognizance or supervised own recognizance. So the schedule is less relevant at that point. And then, of course, once they go to court, we look at things other than a bail schedule. So really, the bail schedule is really, at this point in this county, because of the good work that's being done, is only covering from the point of arrest to about 6 or 7 hours after the booking, when a judge is reviewing that case and determining whether or not the person is eligible for a release. I can also say, just as a point of factual information, in court, once you go to court, if you were to come observe, as of course you're all welcome to do, $0 bail is being used every day in courts throughout the county. Once a case goes to court, a judge, in making the decision on custody status, we are routinely seeing $0 bail being used, even though it's not part of the schedule that we have for bail in the county. And then finally, I want to just point out that I had the pleasure of being the criminal division supervisor during COVID for the judge or for the bench, and so I'm very familiar with the jail population numbers and the efforts, as Mr. Angel mentioned, about jail population and releases, and Mr. Jayadev mentioned it in the letter that he submitted as well, and I remember all of that time far too clearly. But what I will say is that, as was pointed out, the jail population went down by about 1,000 people very quickly, about a third of the population. That was before the zero bail schedule got implemented. That was through a collaborative effort of the district attorney's office, the public defender's office, and the court. And I signed all of those release orders. Those were not zero bail orders. Those were OR and SORP orders that were done to enable people to be released from custody. And so that goes back to my initial point that it's a complex question. Zero bail is certainly part of the discussion, but there are lots of other things that contribute to the jail population that I think can and should be looked at. But I think this is a great discussion, and I'm happy to try to answer any questions anyone has, understanding the limitations of what I can and can't talk about this morning.
Thank you very much, Judge. I'm going to go now to Raj Jayadev, who is the Executive Director of DBUG, which is an advocacy organization for people who are system impacted. And if that wasn't accurate, please do a better job, Raj, with my apologies.
No, that was a great byline. Thank you, Supervisor. Thank you for having us here and giving us the opportunity to share in the discussion. I'm going to present for a few minutes from a community perspective as why we feel bring back $0 bail is so urgently needed in Santa Clara County. Then I'm going to hand it over to a partner that is going to appear on the big screens, Attorney Salil Dudani with Civil Rights Corps, which is a national leading expert on bail policy and bail law. So thank you again for allowing us to share why we believe reinstating $0 bail now is urgent and needed. Our perspective comes from years of supporting community members after they first get arrested and trying to get them released as soon as possible and supporting the release during pre-arraignment stage, as we're discussing, at arraignments, at bail hearings, as well as advocating for the rights if they remain detained. We also support community members and their families through the court experience, whether they're detained, pretrial, or released. During those early days of COVID, right before the emergency bail schedule, as Judge Gaffon noted, we created something that we call the Community Release Project, which I thought was important because it's identifying community supports, not only system reasons why there's a jail reduction. We would go to the jail, we would find ways to get people rides home, we get them phones, we get them care packages, hygiene packets, make sure they knew when their next court date was. And as Judge Gaffon remembers, we were actually literally in the courtroom when he was reviewing that list of who the DA's office and the public defender's office was coming together to get out of that jail. At that time, $0 bail was implemented in the state with the premise that over-incarceration was exceptionally dangerous to those inside the jails and would cause irreparable harm for people once they're out. That reality, with or without a global pandemic, is still true today. and the need to have policies that reduce incarceration are as urgent now as it was then. The other important lesson from the $0 bail period was that the other assumption that releasing people pre-arraignment would cause an increase in crime was proven categorically to be untrue. That is one important data line or graph that wasn't on the previous slides and presentations, but needs to be accounted for. In short, looking back, $0 bail reduced incarceration, the devastating toll on people's lives, without any of the assumed concerns that some in law enforcement stated could be the consequence. This should have been the practice long before COVID. Also, it should be noted that even in places like Los Angeles, a much bigger county, that recently brought back $0 bail, there's been no surge in the rearrest rate of those that were released. What we saw at the end of $0 bail in Santa Clara County, the real toll of those climbing graph points presented by staff, was significant and devastating. People who are held in jail rather than released lose their jobs, their homes, their belongings if they're houseless. Children were left without their parents in their lives, needed elder care didn't happen. Lives were destabilized, some that could not be reconstructed. All within the days in which they were incarcerated from the time of the arrest to the arraignment, which in this county could be close to a week, as the executive's office noted, depends on the day of when the arrest occurred. So even when people made it to arraignment and maybe were given OR, the damage had already been done. The Austin report, which prompted this study session, concluded that reinstating $0 bail is the single most significant way to reduce the jail population. He predicted around 300 people. But those projections were a couple years ago, and the realities happening now show that without the reimplementation of $0 bail, the number of people in jail will increase at an even higher clip than once believed. And secondly, the danger of being in jail is even more threatening. Due to an increase in punitive state laws, more people are at risk of being arrested and incarcerated for the charges $0 bail responds to. Though not the only law, the passage of Prop 36 is representative of how expansive and who the legal system will be targeted in the current era, those with mental health needs, substance use charges, and crimes of poverty. Even in an even more local lens, San Jose policies led by Mayor Mahan, such as the responsibility to shelter, which aims at criminalizing the houseless and those with mental health needs, are signs that arrests for quote-unquote non-serious charges will be increasing. It is exactly these type of charges that state and city criminalization policies are enforcing that $0 bail addresses, misdemeanors and non-serious felonies. And today, in 2025, a jail stay, even in a short duration, can be lethal. Last year, Santa Clara County had the highest number of deaths in the jails in the past 20 years. 10 people died while in custody under the care of the county. In a recent comment to the San Jose Spotlight, the sheriff's spokesman commented on how there are some concerns that jail deaths could worsen with the passage of Prop 36. And most recently, on April 26th of this year, Angelo Spencer, whose family had held a moment of silence in this very room, died after just one day in custody. And beyond the direct harm people are exposed to due to being held in the Santa Clara County Jail, there are portions and segments of our Santa Clara County community that is doubly punished by the forces even beyond our local criminal legal system, our immigrant brothers and sisters. We have never seen this level of aggression from ICE and the federal administration in their attacks of our immigrant communities. As a result, any step taken deeper into the jail system further entrenches immigrants into the ICE enforcement radar, leaving them a target for deportation. And even more concerning, as the sheriff will confirm, ICE is now literally walking to our jails and picking people up upon the release from Elmwood. Keeping our immigrant community's members out of jail is the most effective way to protect them from ICE. $0 bail can be the measure of protection that we have some local control of in the face of federal threats. And lastly, we wanted to conclude with some responses to the presentations that were given earlier in the slideshows. One of the messages that we wanted to make sure was responded to, that we're hoping some people don't walk away with, has to do with the conflation of releases and being under supervision. I think there was really unanimous agreement that no one here believes in money bail as a proxy for detention. The challenge, though, is that looking at those data points that were shared and knowing what the difference was between freedom, temporary incarceration, or a net widening of e-incarceration. So for example, when we look at the argument of whether we should bring back $0 bail or not, there wasn't really shared earlier today an argument to say no. The only argument or debate was really about the scope or impact of what that would do, whether it was nominal or significant. And I think to the public defender's point, I think we should look at that data. But one thing that's important, another dimension, is that it's not a binary of who is literally in jail and who is not in jail. It's also about who is under system control. And as the pretrial office would note, while that's helpful to be out of jail, being under supervision is also a limit of freedom. And in this county, with the onset of $0 bail and some of the shifts that were noted earlier by the county executive's office, while we saw a reduction of who is physically in the jail, we saw a dramatic increase of who is under county supervision. The number of people on electronic monitoring quadrupled, and that's common with what's happening across the state. In San Francisco, just north of us, there's a 300% increase of people held on electronic monitoring, even while they made efforts to reduce the jail population. So lastly, I guess I just wanted to say it's awkward to feel like we're in a debate of two sides when it doesn't sound like we've heard another side. It's really a question about how good do we want to be. And I would argue from our community perspective of what we've seen, I haven't heard a single argument on why we should keep prohibiting $0 bail. If we're saying that, look, we're doing pretty good without it, we have other devices that essentially equate to the same outcome, why still maintain the prohibition of $0 bail on the books? Why still leave us liable or vulnerable for it to be used with another set of actors or court actors? And if we all believe that money bail is a discriminatory practice that harms and is unfair to our most vulnerable, why not just excise it from our county ethos of the courts and get our people free, get our people whole, and get back on the track of reducing the population numbers in our jail? With that said, I did want to hand the presentation over to our partner, Civil Rights Corps, who I think is going to give us a larger context and lens as to how $0 bail is playing out in other counties across the state and what we could do here in Santa Clara County. So with that, maybe we could see if he could join us on the big screen. Salil, are you there?
Yeah, hi.
Hey. Welcome.
Thank you so much. I doubt I'll be as eloquent as Raj, but I'll try to be useful. So my name's Salil. I'm a senior attorney with Civil Rights Corps. We're the organization that represented Mr. Humphrey in the California Supreme Court in the In re Humphrey case. And we're a national organization that works on pretrial issues all over, but I personally focus on bail in California. And one of the reasons I'm happy to be here is that I always enjoy talking to folks from Santa Clara. I think in a couple respects, Santa Clara is a real leader in the pretrial space. There is this understanding in this room that money bail doesn't serve any purpose and is just discrimination. That's it's a very, very well established empirical fact, but not every official in California understands that, I'll put it that way. Santa Clara has this robust independent pretrial services agency, the investment in early representation of people pre-arraignment. So when I'm going around talking to other officials across the state, I am often citing Santa Clara as a model. I think that when it comes to the bail schedule, Santa Clara actually has something to learn from other jurisdictions. Because ultimately my assessment is that, I think the reason we're here is that by and large, Santa Clara's bail schedule is one of these traditional and more outdated, frankly, bail schedules. And so I want to focus on the example of Los Angeles, because LA is this example of what you might call a $0 bail schedule with automatic release provisions in those nonviolent felonies and misdemeanors. It's been in place for going on 2 years now, so solidly post-pandemic. And it's been studied very closely. And it's been proven to be consistent with public safety or enhance public safety. Before I get into all that, I just want to make clear that what we're really talking about here primarily is just this pre-arraignment period. So as Judge Gaffon explained, once a person gets to court and there's a formal criminal case and the district attorney has made the charging decision and they have a lawyer and they're in front of a judge, the bail schedule really shouldn't be relevant because that case in Ray Humphrey sets forth the standards for an individualized bail determination. So the primary thing we're talking about is pre-arraignment detention, which really is quite significant. We're talking about 2 to 6 days of jailing from arrest to arraignment. And so, you know, I'm saying primarily because there are some ripple effects. Like, for example, if someone receives a citation under a $0 bail policy and walks into court out of custody, they have proven to the judge that they're not really a flight risk, right? They showed up. So the judge is much more likely to keep them out of custody. So there's some ripple effects which are important and good. But we're mainly talking about pre-arraignment detention before the district attorney is involved, before any hearing or anything like that. I would not, I think it's very useful, the context Judge Gaffon provided, and very important, and something that the county should kind of be curious about data-wise, about the pre-arraignment screening that Judge Gaffon described. But I wouldn't, take for granted that the issue of pre-arraignment money bail pursuant to the schedule is just the first 6 hours. I think that would really depend on the data about the pre-arraignment release rates. And when I say that, I have in mind experience I have from elsewhere, very much including Los Angeles, unfortunately, where, under the old regime, under the old bail schedule, and under the new bail schedule, there is, a significant amount of nominal review by the magistrates. And what we find, unfortunately, is that the actual release rates are very low. And I'm not trying to impugn any judges here or there. The reality is the way things are presented prior to a hearing, pre-arraignment, there's no input from the defense, right? It's just the, a police narrative, a criminal history, kind of the adverse facts, right? So it's somewhat understandable that a judge may not be likely to release a person in that setting. So my point is just that I wouldn't presume that, there is going to be some number of cases where a person does not get relief from that monetary amount prior to arraignment. Okay, so we're talking about this, 2 to 6 days or so. I want to talk a little bit about the research about how important that period is, because frankly, even I find it counterintuitive and surprising, the extent of the harms the research has uncovered to the individuals involved and their families, and actually the community at large. So, one of the most obvious points is a person can lose their job, right? If you don't show up to work for 1 or 2 or 3 or 4 or 5 days, you could lose your job. And in fact, there was a study that only focused on individuals who did have strong work histories, and found that these individuals had been jailed 4 to 7 days, and 46% of people reported losing their job. The effects of the lifetime effects on diminished earnings, according to one very rigorous Harvard study, of just 3 days of pretrial jailing is a loss of $29,000 in lifetime earnings, which is, of course, a lot of money for the largely indigent people in the criminal system. Then there's the likelihood of a post-conviction sentence. So if you're in jail pretrial, and I'm sure this is a familiar fact to the people in this room, if you're in jail pretrial, holding everything else equal, it's more likely that you will be convicted and receive a harsher sentence. Now, here's the perhaps surprising thing. There was a recent, very large, very rigorous study, and it found that the people released on the day of arrest in that sample had a 4% chance of post-conviction incarceration. The people who were detained just 1 to 5 days had a 15% chance of post-conviction incarceration. So that effect is kicking in really fast and has significant consequences for the individual and the county. Then there's the issue of family separation. It's common sense, and the academic research confirms that it's harmful to children, especially young children, psychologically, to have their parent taken away from them. And the last harm I'll highlight is a very important one, which is how destabilizing, stressful, frightening, counterproductive, inherently the experience of being jailed is for individuals with mental health or with physical health problems that can be set back. And the kind of data point I would make here is that, in general, nationally, the leading cause of death in jails is suicide. And the key point I want to make here is that that's typically happening within the first few days of jailing, which shows how much of an effect this has. So this next point, I think, is maybe the most important thing I'll say today. So yes, there's all these harms to individuals. What the research has now shown very many times in studies, very rigorous studies across the country, is that even short-term pretrial jailing is criminogenic and has been proven to cause more crimes. And, I think our culture hasn't really caught up to this finding, right? We talk about these issues like, typically, these issues are talked about like, okay, we're balancing the rights and interests of the individuals who may be incarcerated against the need for public safety. And, maybe public safety will be unaffected if we release more people. Maybe it'll be negatively affected. That is not the right way to look at this under the current social science research. It is actively causing more crime to the extent there's any unnecessary pretrial jailing. So there's a lot of studies. I just want to briefly give two examples. There was one study with a huge data set coming out of Texas, literally controlling for hundreds of variables. And it found, this is quite remarkable to me, it found that just 7 days in jail on a low-level offense increases the odds that that person will commit a felony in the following 18 months by 32%, because it's that destabilizing and undermining of public safety, even brief jailing. There was a follow-up study that looked at a longer time horizon, 3 years out, and found that even at that distance in time, we're talking about, it was a 8.5% decrease in future felonies caused by a reform that released low-level people without money bail rather than imposing money bail and therefore more detention. And there's lots of findings, but I just wanted to really emphasize that because I think it reframes the discussion a little bit and the urgency.
Thank you so much. Oh, sorry, did you have something else?
Yes, I just wanted to close the circle on LA and what I think the implication is for Santa Clara. So since 2023, LA has had this $0 bail schedule that it calls a PARP, the Pre-Arraignment Release Protocol, and it calls its $0 categories, its automatic release categories, CR and BR, cite and release, or book and release. It's been, if you go on the LA Superior Court's website, they've put out numerous, data analyses showing that actually rearrest rates have gone down since the passage of their $0 bail schedule. And Joanna Lecoe and others at the Cal Policy Lab were asked by the state to study this rigorously. And they put out a paper in 2024 called The Short-Term Impacts of Bail Policy on Crime in LA. And unsurprisingly, they find that there's no relationship to crime rates caused by the new bail schedule. And so, Santa Clara's misdemeanor bail schedule has OR as an entry in some places, but really typically where the action is in terms of decarceration is the nonviolent felonies. And that's the key place where Santa Clara's bail schedule on the books does have money bail, unlike LA's. And so I echo what Raj said so eloquently, that the exact number of people who will benefit and the exact amount that public safety will be enhanced, whether it's X or Y or Z, I think it's a no-lose proposition to try to get $0 bail schedule in Santa Clara, particularly particularly because there is liability, and it's very straightforwardly unconstitutional. Court after court after court has held that, and that impacts the county and the sheriff, that liability, not just the court. So I'm happy to answer questions about any of that and to share thoughts on what particular data requests of pretrial services or the court could move the needle. And I
Great.
also echo what Mr. Silver said about digging into exactly the citation authority that the sheriff has to tackle this another way.
Thank you very much. I appreciate all of the presenters this morning. I'm going to look for lights, comments, questions, engagement, and I will start with COO Greta Hansen.
I just had a quick question for Mr. Dudani, actually, just to clarify something that I thought I understood from what he shared and wanted to make sure I had the correct takeaway. What I thought I understood you to say was, or two items I just wanted to lift up to make sure I heard them correctly were in your view, and I think, and I was curious to hear from my colleagues on the dais whether this was their view as well. I thought I heard you say that maybe the most impactful place to look is in that pre-arraignment arena, and to see where what our data looks like in terms of who is held pre-arraignment as opposed to post-arraignment. And then the other thing that I thought I heard you say and wanted to make sure I heard you correctly was that although, I take your point about the question, why not have $0 bail in place, which again is mostly a question, or is only a question really for the court and not for the other folks on this panel, putting aside some of the questions that Mr. Silver mentioned were worth looking into related to non-court-based authority. But I did want to just make sure I understood what I thought was a comment from you saying that you are not seeing the impact of the return of $0 bail in Los Angeles that you expected to see, or maybe I misunderstood what you were saying.
No, sorry, I was confusing. That Cal Policy Lab study found that the jail population in LA went down several hundred as a result of the reform bail schedule. And actually that's a really big undercount because they looked at the county jail population, but unlike in Santa Clara, most pre-arraignment detainees in LA are held in booking stations, that like police station jails across the county, not the county jail population. So there was a decarceral effect that was significant. Yes, the pre-arraignment period is the most relevant period for what we're talking about today, because that's the only time the bail schedule is binding and determines a person's custody status. And about the data, I would think that it would be decarceral in Santa Clara too, in light of the 2024 Austin report, projecting a 250 to 300 drop. I think that I think there is some discrepancy with the district attorney's office's data between the 70 and the 84 that I'm seeing on the county's numbers versus the district attorney's. That may be explained if the district attorney's office used their formal, like the district attorney charges. If they use their internal data, that's different than pre-arraignment, before the district attorney is involved at all and law enforcement has just booked someone. And so I think the county can act without more data, just to be clear. I think the county can and should formally request the court, this is impacting us. We don't want the liability. We don't want the folks in our jail. We think you should just update and revise the bail schedule on the books to align with the best practice, like in LA. But if there is interest in data, I think you'd want to ask pretrial services and the court, details of who is screened prior to arraignment, what's their PSA score, what's their booking charge, and then what's the outcome of that magistrate review that Judge Gaffon described. And you'd also want to ask the sheriff about what are the exact policies regarding citation and what's the full extent of that citation authority.
Thank you. Kavita?
I think Sylvia might have been before me.
Oh, thank you, Sylvia.
Just to piggyback on those earlier comments by the presenter, I think our reality is that if the court holds a lot of the power and authority as the key decision maker at this critical juncture, one thing to consider in addition is that recognizing judicial independence, recognizing their duty to address the critical point of public safety. Could we move forward with another conversation about addressing some of the concerns that judges may have in either the elimination or the return of zero bail, but also how they are applying the current bail schedule? Because I think if we fill the gap in terms of assuring them that the clients were going to come back and there's not going to be a reoffense, and providing that peace of mind, which at the end of the day is what matters, then I think we can get to this outcome. I think since we agree with, at least on our side, it sounds like we all agree that $0 bail would be a great strategy. The question is, how do we move the needle with the bench, and how do we engage with them to give them the information that they need in order for them to make the best possible decisions at that critical juncture? Because this conversation is great, but we need to persuade and influence the decision maker, because what we see in court every day is we are still using bail, people are still using cash bail. It's giving the judges some assurance of some sort, whether we agree with it or not, it's still happening. And how do we move away from that? Well, we need to shift the paradigm of what other information and assurances they need, not to rely on it. The other alternative, unfortunately, is that there's still going to be people detained without bail at all, right? So anyway, I thought that might be something that we could consider.
And what do you know? We have the court here.
Here we are. I'll say just a couple of things. The first is that obviously the more information that the judge has at the time they're making the decision, the better. I know that there is the pre-arraignment review program that is relatively new, which has been, I think, very helpful. And I know from talking to colleagues, very helpful, because when an arraignment comes before us, traditionally, back in the day, as we say, we didn't know anything about the person in front of us except what they're charged with. Having the public defender's office and your office get involved earlier in the process, meet with people, be able to give us information about that is very helpful, and I would encourage as much of that effort as possible, because I do think that's very helpful. The other thing I'll say relative to the comments is that while I mentioned earlier that the court's yearly discussion about bail is done internally, and it really there's just no way that it cannot be done internally. We have and we will continue to disseminate information that's provided to us by outside agency. We've had some from Mr. Jayadev in the past about the bail policy. We distribute that to all judges before we have our discussion. So we're happy to take in information and give it to our judges to consider, but it has to be done in that way so that our discussion can remain consistent with our ethical rules. But I would encourage people to provide information that you think is appropriate. Generally, just so you know, we usually are dealing with a bail schedule at our January meeting, which means we are discussing it to propose a schedule in the fall to prepare for the next year. So as far as the timeline, that's how we usually do it.
Perfect, thank you. I'm going to go to Kavita, I can't tell if it's Damon or Nick's light.
It's mine.
Damon's light. Greta, then Greta. And I want to make sure I remember to go to public comment as well. I haven't done that yet. Kavita, go ahead,
Thank you,
please.
Supervisor. I was about to say I'll try and be very brief, being cognizant that we haven't heard from the public yet. So just a couple comments. I think others have said this. We are hearing similar goals from just about everybody who's speaking, and a conversation about how we get to those goals through what policies. The thing I wanted to comment on briefly is just the ability or not to draw analogs between the Los Angeles situation and our own for a couple reasons. One is that, as Mr. Dudani noted, Los Angeles has a couple things that are called cite and release and book and release, and those are the LA analogs of programs that we have really robustly in our county as well. You know, LA has 88 cities within their county, and in contrast, we have 15, which we feel is a big number of cities to coordinate among. The reason I bring that up is that there's been a lot of work done in this county for more than a decade to work on consistency of cite and release across the law enforcement agencies so that they're taking as much as possible a similar approach. And then where someone isn't cited and released in the field and is instead brought to jail, our jail is using the penal code presumptions of cite and release for as many charges as they can. And that's a prevention deflection approach of not having someone enter custody in the first place. So I just wanted to comment on that. You know, another thing is, as Judge Geffen pointed out, the COVID population reductions, much of that in our county was done in the very, very earliest days through collaborative efforts at the system, not just through the $0 bail schedule. So all of these things are sort of complementary approaches that can have an impact. And then as far as the LA changes, the numbers in terms of the reductions of a couple of hundred that have been seen from the changes they've made, the baseline situation in LA was quite different from what we have here. So if my understanding is correct, in the LA situation prior to this litigation, the baseline was that they were using bail in the first instance without a magistrate assessing someone for other release options prior to arraignment, which, as Judge Geffen pointed out, is the exact opposite of what occurs here in our county. So the kinds of numbers that we may see, I think the analog just isn't a very close match due to that difference in the pre-$0 bail situation.
Thank you. Damon.
I promised. I promised to be brief. I think it is important, though, Kavita, that you brought up this issue about the magistrate, and I know that Judge Geffen has done this as well. And we actually look forward to engage and re-engage the court about some penal code obligations about what a client or a detainee has in terms of rights to actually provide information to the magistrate judge, which we feel is limited or really has not been provided at this point pursuant to Penal Code 1269C and 810. And there really is an opportunity, even though LA County did not have a magistrate system, our county does, and actually has enabled and amplified the voice of law enforcement in interacting with the magistrate judge, and has not actually provided a similar avenue for the defense. And we look forward to trying to build that particular bridge so that we can do that advocacy. The real last observation I'll make, which I'll kind of describe as the elephant in the room, which is us collectively, including the court, really needs to probably ask the question of what happens if we do not do something? Because the reality is we're already challenged in providing proper care for the people who are in our custody and have already been directed to reduce that custody. And the question is do we as a collective want to lose control through basically liability and litigation? And I would suggest none of us want that, because we want to be able to make decisions that are right for our community and right for safety of the community. And so for all of us working collectively, and I appreciate Judge Geffen continuing to invite this dialogue with the court and information providing to the court, I suspect there is actually more alignment than we may see in the final vote about $0 bail at this point. That's all I wanted to add.
Thank you, Greta. And then I'm going to go back to our online speaker, and then if there aren't then my colleague, and then to the public.
Well, maybe knowing that we're running out of time, I just wanted to share a comment that, the public should know that there's many conversations happening besides just this one, happening at Public Safety and Justice to really unpack some of these things, many efforts afoot on behalf of all the folks involved here to try and collect and share better data on where these opportunities really are. And then also a need to get creative. And I think this kind of highlights the point that Kavita just made about what makes sense in our county, given the infrastructure and actually really robust collaborative resources that we have and shared philosophy that we have around a lot of these questions. And so in particular, I was just gonna say that I appreciate the opportunity also to work more closely with the court to figure out what are the ways to make sure that the judges who are making these decisions have all the tools and information at their disposal to make the choices that I think we want to make, and also to better understand, knowing that you do have a wide variety of judges, some with lots and lots of experience in criminal court before joining the bench, some with zero experience in criminal court who may be really looking to the bail schedule or other things to guide their exercise of discretion to make sure that the county actors can provide the court with the best information possible to effectuate what we think is kind of a shared philosophical approach, including through things that, we have some models in place. PAR is only one, but really getting better guidance also from the court on what information it hopes to have presented to it in that pre-arraignment detention phase, and then to figure out the most cost-effective way and appropriate way to make sure that that information is being provided to the court, because even where we had PAR in place, it wasn't able to serve the bulk of the folks who are perhaps needing a higher level of support in the court.
Thank you, Greta. Khalil, then Supervisor Lee.
I just want to very briefly share that there actually was magistrate review of every arrestee statutorily eligible for release in LA prior to the reform there. They called it the PrEP program. And there was still a significant reduction in the jail population and the pre-arraignment custody population following the $0 bail reform. Thanks.
Thank you very much. President, Supervisor, and Vice Chair Lee.
Sure. Well, so thank you so much for this. Has been a really comprehensive presentation. I want to thank all the folks who came up and speak from the community as well. And this is something that we've been talking about for many, many years, originating from the fact that just so many people are being held in jail because they could not afford bail. The COVID period certainly has given us a very good snapshot for a few years of how this policy has worked. And there's always been a so-called common sense understanding, which turned out based on research exactly the opposite, that says if you get people, kept them in jail, the fact that they are in jail, therefore there will be less crime being committed. And what we just heard from the research is that it's the exact opposite, that 30% of those would be more likely to commit felony in the next 18 months if they were held for those first 7 days. So I think those are some pretty dramatic and unfortunate fact that we need to understand the impact of this devastation for people being held when they don't need to be. I actually have a question with the judge about the option. If the county were to adopt the zero bail, that option being taken away from the judges. Now, judges still have the option to impose electronic monitoring versus no release. Is that correct?
Yeah, a judge always has the option of non-monetary conditions as part of any release, whether it includes monetary bail or not. Electronic monitoring is one of the options that a judge would have.
Right, because right now, basically, the options are you could have a bail, a dollar bail, in addition to these two that we just talked about. Because at the end of the day, I'm looking at it as this bail system has been around for decades. And frankly, I've never really understood it from the day it started. It's like, if the person should not be released for public safety, for all these other reasons, they should not be released, period. And when folks are able to provide a dollar amount, I understand they're trying to guarantee them show up to court, otherwise they might not show up, right? That's really the purpose of bail. That's how we created the differentiation of those who can afford get to go and those who can't afford have to be stuck in jail. And not having to repeat all the reasons why that system doesn't make any sense to me. I just think that this zero bail issue or concept is something that is long overdue in many ways. And I hope that continuing forward on, I don't know, I'm going to ask the chair, since you're the one who asked for this to come forward. Is this the point where we make a recommendation to move this discussion to the full board in the future?
I'd like to take that under advisement. Today really was to learn, to hear from experts, to be clear on our purview, to which extent I want to ask Kavita for a clarification. Judge's light is off, and then I think we'll move toward wrapping this up, but the public needs to still weigh in.
Okay, thank you.
But go ahead, Kavita.
I will absolutely defer to any other comments that Judge Geffen would like to give. Just on the point about $0 bail, to be crystal clear about that, it's not a decision that could be taken from the court and given to the county to make under state law. Only the court can make that decision. The county, of course, supervises, monitors people who are on pretrial release, but even those options must be ordered by the court.
And Supervisor, I'll just add finally that your observation is correct in that the penal code has lots of provisions about bail and how it operates. Those have been on the books for decades. Many of them do not recognize the sort of current thinking on it, and they aren't really consistent with that. So part of the difficulty is taking the Humphreys case and the current laws and still applying statutes that are still on the books and are still valid that we're required to follow that maybe didn't contemplate that, and it does create sometimes a bit of a conflict.
Thank you. I don't see lights. I'm going to see if we have public speakers on this item.
We have one request to speak from an individual in chambers and none on Zoom.
One in each?
No, just one, total.
Oh, yes. Thank you. Let's hear from our single speaker, and thank you for your patience.
Bernie Mills, if you could approach the podium.
We may have exceeded his patience. I am sorry about that. And he's not on Zoom. Can switch to
No,
Zoom.
not
All
on
right.
Zoom.
We did run long, so to members of the public who weren't able to speak, my apologies for that. I wanted to have all of the information that we could in front of us. I want to express tremendous appreciation to everyone on both sides of me, and Raj and Khalil and David, for really sharing just fascinating information, keeping us accurate, keeping us within each department's purview, and understanding all of the ways in which collaboratively we each have a role in ensuring that the people who are held in custody are truly the folks who are determined to be unsafe, to pose unsafe risks to themselves or to the population if they weren't. This clearly is not the end of the issue. I'm not going to issue direction today, but just thank everyone for the conversation and look forward to hearing from any and all of you about proposed next steps in your areas. I think the judge has made clear that the court is going to be taking up this issue for the coming year over the next few months, so certainly our timing is right. I'm quite certain you heard all of us, and want to as well be clear that we are here to work with you and to be supportive of the bench in Santa Clara County. So thank you. Item 9 on,
I do have
go
one
ahead.
questions. One is, do we need to move to receive report first? And two is, I do have some question regarding the risk assessment tool.
It's not a report. It was a study session, so without direction, we don't need a motion. But if you had a question that you need to ask before we go on to our final item, I'm happy to take that.
Sure. I believe we have a risk assessment tool, and I just want to know if this is possible for us to get a report back to learn more at the PSJC regarding our current risk assessment tool being used by our pretrial services staff based on its efficacy and shortfalls.
I
Is this
see a
something
nod
doable?
from Matt Fisk.
Yes, we'd be happy to do so.
Great, all right. So
Great.
that would be my request, and I
I'm
don't have
happy
to make a
to
motion. Thank you
second
so much.
that direction in your motion. Nancy?
Vice Chairperson Lee.
Lee, aye.
And Chairperson Ellenberg.
Yes.
Thank you.
Thank you.
Thank you very much. Item 9 is the time for announcements. Do we have any announcements from any folks on the dais? Seeing none, again, really extend my appreciation to all of you. We ran a little bit long today, but I hope that you felt the time was worthwhile. I'm going to adjourn this meeting. Our next regular meeting is scheduled for Thursday, August 14th, right here at 10 a.m.